delighted to have with us Advocate Lalit Kumar. He is an Indian patent advisor, patent attorney, and an author with over 15 years of experience in intellectual property. As an associate partner at a well known law firm, he works closely with startups and businesses, and he helps them protect their ideas and position them strategically in the market. Because today, intellectual property isn't just legal jargon, it's a key part of entrepreneurship and success in the Indian market. Through his work, his courses, and his book, The Playground of Patents, he has helped thousands understand how innovation translates into real world value. Today, he'll be sharing with us insights on entrepreneurship, investment thinking, the Indian market, and intellectual property. Now, just before we begin, a quick note on decorum. We request that everyone keep their phones on silent and avoid interruptions during the session so we can all make the most of this opportunity. We'll be taking questions at the end of the session, so feel free to note them down as we go along. And with that, please join me in warmly welcoming Sir Advocate Lalit Kumar. Good afternoon, sir.
Thank you so much, Darsh, for this kind introduction, and I welcome you all for this session. And I first of all congratulate for this initiative so that it helps everyone to understand the IP landscape and what different things are there in IP, so that everyone can protect their ideas and make valuable assets out of them. Sure, so I'll start with a simple question or thinking maybe. What makes an idea truly valuable? Because everyone has ideas in their mind, but it is not that everyone have same level of maybe value added to those ideas, right? So if on a day-to-day basis thousands of ideas crosses our mind, but not every idea gets that shape that other successful ideas get, right? So what makes an idea successful and keeps it apart from the other ideas is what we are going to discuss today. And we will discuss how ideas are conceived, how values are created out of them. So this is what we are going to understand today. So as Darsh mentioned, we will take questions at the end of the session. So if you have some question, please park them aside for the moment. This will be beneficial for the value of time others have, because if you ask question in between, so maybe it disturbs the flow and it is not good for others. So just a request, please keep your questions parked aside for the last part of the session. Okay, so as Darsh introduced me to the audience, I'm Lalit Kumar, and I'm working in this domain, IP, intellectual property field, for last 15 years or so, and particularly in the patents domain. So patents, all sorts of prior art searching, freedom to operate, landscape studies, patent application filing, and I help inventors in all sorts of help I can provide so that they can secure their ideas. So I have my YouTube channel, Udemy courses I have, and all across social media I have channels where I help people to understand what is IP, how they can leverage it to secure their ideas and create a value out of it. So I'm present all across social media channels. I have my website patentmyidea.in. You can reach out to me on LinkedIn as well, and many other channels. So on my Udemy channel, I have around 5,000 plus students from 139 countries, and most of them are from India, and but other jurisdictions or countries I have people from these domains. So I have courses on patentability searches, landscape analysis, how to draft a patent application, and such other stuffs. So if you want, you can check it out. And as Darsh mentioned, I have a book written to understand the complex jargon of patents, because not everyone can understand different terms or different ideas disclosed in Patent Act. So I've tried to simplify it through my book, The Playground of Patents. It is available or published on Amazon. You can check it out also. So in this today's session, what we are going to learn is the genesis of invention, how a invention starts its journey, how ideas are conceived, the journey of invention towards patents, how a idea we can take a idea from its conceivement to its final journey, which is patent. So this is we are going to learn. Then we will understand, once the idea is there in your mind, how will you validate it, whether it is worth patenting, whether it will get a patent or not. So this is we are going to learn. Then we will learn procedures to validate the idea and how a patent application is drafted. Then we will learn about patent application filing and other procedural events that follows after the filing. So and we will learn about patent application prosecution and how a patent application is finally disposed, whether it is, how actually it is uh, granted a patent or refused by the patent office. And at last we will learn about some blunders that everybody should avoid at any cost, so that their invention gets at a patent and doesn't get into hurdles of not getting a patent granted. So this is what we are going to learn today at a very outset. So I'll start with the first topic, which is genesis of invention, or how a idea is start, or how invention starts. So as this whole journey of a patent starts from recognition of a problem. So what happens, everybody comes across a number of issues or problems in their day-to-day life, right? So those problems are what creates or helps create inventions. So if you are somebody who observes problems in day-to-day life, particularly technical problems, then it is highly likely that you will think about solution for this, for solving that problem, and that will become your innovation or invention, and that will give you a premise of creating an innovation, right? So the first step is the recognition of a problem. So if you are dealing with some problem, if maybe a device is not working the way you want, whether its efficiency is not that good, if you identify that problem or recognize it, then you are already half, you have traveled the half journey of it, I mean the journey of getting a patent granted. If you recognize a problem and you bothers to solve it, then you have traveled the half of the distance that goes to get a patent granted, or the journey of a patent. So the very first genesis of innovation is the recognition to a problem, and that the solution of that problem becomes the answer or the innovation, and that solution you can patent it. So this is how somebody can conceive a solution. First he has to recognize, he or she has to recognize the problem, and then once he decides that this is a problem he can solve, then he can come up with a solution and try to provide some sort of implementation for the solution, so that implementation becomes its innovation. So this is how ideas are converted from ideas to patents or intellectual property or IP. And out of ideas, because ideas are not tangible form, they are intangible, you cannot see or touch them. So if something is there in your mind and you have something in your mind, you can make it tangible asset, and you can convert it to a tangible asset by way of patents. So if you have something in your mind and you want to convert it into tangible form, what you have to do, you have to make it you have to convert it into a patent. So that patent becomes an intellectual property, and intellectual property is similar to other forms of properties, maybe a land, because once you have a patent, it becomes a property you can sell it, you can exchange it, you can assign it to somebody, like other forms of property. So this is how genesis of an invention happens. So journey of invention is quite lengthy. Once you start conceivement of an idea, and I just mentioned or disclosed to you that how ideas can be patented. So the first step is problem solution approach. You identify a problem and you think of a solution for it. Then it is the genesis, and it is the first step of in the process of getting a patent. The next step is the validation of patentability. So not every idea is patentable, because what happens if you identify a problem and you come up with a solution for it, then I mean there is always a chance that somebody might have thought about the same problem and maybe substantially similar problem. So it is not that idea comes to your mind and you directly go ahead and get a patent for it. So what we need to do first is that we need to validate the idea. Validation is that if somebody has already filed a patent application for it, or somebody has already make a product out of similar thought. So this is something we need to check first, and this is called the validity of the validation of patentability. So patentability validation of patent is the second step. Then we have post search procedures and patent application filing. So once you validate the patentability of your invention, then the next step is to prepare the patent application. And once you prepare the patent application by writing a patent application, patent specification, then you can file it with the patent office. Then these are filing and procedural events for filing a patent application. And after you file a patent application, prosecution or examination of your patent application happens, and the patent office assess the patentability of the invention on the parameters of novelty, inventive step, and industrial application. So once you file a patent application and it goes into examination or prosecution, now the ball is in the patent application court. What you have filed as a patent application, they will assess it or evaluate it on the parameters written in the Patent Act, and then once they have done the examination, they will dispose of the application. So disposal is the final refusal or grant of the patent. So this is how a journey of a patent looks like. It starts from problem solution or identification of a problem and stops at the disposal of the patent application. Disposal is either it can be a grant, a patent grant, you get a patent grant, or refusal because the idea was not novel or it was not inventive. The patent office might grant you a patent or refuse a patent. So this is the broad form of patent application filing and up until the grant and refusal of it. Now the very important part is the validation of patentability, because in this journey of patent field, I've seen many ideas going through this process, but I've also seen that patent applications are directly filed because when someone conceives an idea, he got very excited that I found something very remarkable and it will change the world. So what happens, in the hurry of things, he will directly go ahead and start the patent application filing without consulting anyone or without assessing the patentability of the invention. So what they do, they come up with their idea, they draft a patent application maybe by themselves or with the help of attorney. They draft a patent application and file it without evaluating the patentability of their invention. So what will happen in that case, that you invested your time, money, and energy in finalizing your patent application, and once the patent application goes into examination or prosecution at the patent office side, what will happen? Chances are there that your idea might have been conceived by someone else already, and there is a patent in India or in US or China, anywhere in any jurisdictions. The patent office have databases to access all the all the patent application filed by anyone in the world. So they run search strings and identify the exact same thing or exact same invention filed by someone else in other jurisdictions or maybe in India also. So they will reject the patent application, citing that there is no novelty. The patent application or the invention that you have filed is not new and somebody has already filed. So all the energy, all the money, all the efforts that you have put in will go into waste because your idea was not novel. So it is my recommendation that whenever you conceive an idea and you want to file a patent application to get a patent, first of all, do due diligence to identify whether the idea is novel or not. So to check the validation or to validate the invention, the process we follow is called the prior art search. So prior art search is the study or due diligence we do to validate the idea, whether the idea is novel or not. And in this prior art search, the patent office evaluate the patent in 3 parameters. I already mentioned about it. I will repeat it. The first one is the novelty. The invention should be new or novel. It should not be there in public domain already. This is the first criteria. Second one is that it should have inventive step. Inventive step is that if your idea is new, suppose that your idea is new, then it should also have some technical leap over the existing inventions. So whatever is the state of the art at that moment or state of innovation in that domain, your invention should add certain value to get a patent. So this is called the inventive step requirement of the Patent Act. So section 21JA of Indian Patent Act defines inventive step, and every invention needs to fulfill this to get a patent granted. There is a third element or third criteria which is called the industrial application. So the idea or innovation that you want to patent, it should have industrial application. It should either be made in industry, or it can be manufactured in industry, or it can be used in industry. So this is the third criteria. You have seen one more criteria, which is obviousness. It is not a criteria written in the Patent Act, but it is very important, and I will talk about it, which is called this is obviousness. So during the inventive step analysis, maybe your idea is new and your idea is inventive, but if we compare already identified or already filed patent application with your application, maybe the examiner thinks that there is the improvement that you have done in your patent application are not that great for which a patent should be granted, and the invention that you are proposing is kind of obvious in terms of what is already there in public domain. So this is called obviousness analysis. I will talk more about it through an example also. So first of all, I will talk about types of prior art. So first of all, I will talk about what is prior art. So during the assessment of patentability, we have to perform a search which is called prior art search, and a prior art is everything which is there in public domain prior to your invention is called a prior art. So it can either be patent literature or it can be non-patent literature. So patent literature is all the patent application combined anywhere in the world. All the patent application filed in either in India, in Japan, in US. So all the patent applications they are combined and called patent literature, and everything else which is not part of patent literature is called non-patent literature. So scientific papers, white papers, publication made on blogs, or publications made on YouTube, or any kind of vlog. So everything which is not patent is non-patent literature. So prior art search is performed to identify relevant prior art of that domain. So this search is performed to identify whether your invention is being discussed or talked about by somebody in public domain, and it is not part of the public domain already. So if those criterias are satisfied, then only patent office grant you a patent. So this is called prior art search, and there are two kind of prior arts. One is patent and other is non-patent. So I hope you are clear about all those things so far. So for patent databases, we have these databases, free databases in particular, which is Google Patents, and eSpaceNet is there. The Google Patent is from Google. eSpaceNet is an official patent database from European Patent Office, EPO. So you can go these four websites. The other one is WIPO. This is World Intellectual Property Organization's patent database, WIPO, and one is this PQI. This is AI based prior art search performing tool, which is recently published by someone, and it is, these all four patent databases are free. Anybody can go, they can put some keywords and they can identify prior art references which are relevant for your innovation. So these are four free patent databases. You can go and check it out too. If you have something in your mind and you want to assess its patentability, then you can go to these websites or web pages and put some search strings based on your innovation, and then all the patent related to your innovations will come in front of you, and you can assess them to check validity of your patent application. For non-patent databases, we have search engines, for example Google, and all the research paper publication websites such as IEEE and other journals, scientific journals. They publish day-to-day technical features or technical papers published by students across the world, PhD holders or PhD persons who are doing these searches. So they all can go, you can go to these websites and perform patent and all patent literature searches. You can go to YouTube also. You can put some keywords related to your patent application or your innovation, and then you can, maybe because many times people just directly make some sort of prototype and make a video of it and publish on YouTube, and you can go to different blogs also. So everything which is related to your innovation, which is disclosing something that you want to propose, or you want to get a patent, you want to file a patent application for, you can go and you can check it out to see whether it is novel or new or not. Okay, so now we can come to how these searches are conducted. So once you conceive the idea, then you have to identify what are the novel features or what you want to protect in your patent application. So if you have these things in front of you, you can identify some keywords, most relevant keywords from your patent application, and then you can run those keywords. You can put those keywords on the search as a part of search strings, and then you can identify prior arts which are similar to your innovations. There are some operators to broaden the scope of your patent application. To perform the prior art search. So for example, if your invention is related to cycle, maybe bicycle, then you have to put the bicycle as a keyword. But if you want to broaden the scope, you can put or as an operator, and you can put one more keyword. So the other replacement of bicycle may be a vehicle, you can use as a keyword. So to increase the scope or to broaden the horizon of your search, you can use these operators. So these are very simple operators. Only we use these on free databases. We have some paid databases also where there are advanced operators used. So because most of you will be using free databases, so I'm talking about these free websites that provide and what operators they offer to you. So this is there is one more operator which is used to increase the relevancy of your patent of your search. So and is another operator that you can use, and it will help you increase relevancy of your patent application, sorry, your search. So for example your innovation was related to cycle, so you first put a keyword related to cycle, but in addition to cycle you have improved upon the handle of the cycle. So the prior art relevant to you is not just cycles, but those which are talking about handles. So alongside bicycle you will use and operator, and you will put one more keyword related to handle. So now you will see only those prior art references that talks about bicycle as well as handle. So this way you can use n number of and operators, bicycle and handle, and maybe some other thing, some other point that you want to include in your search. So this way you will see more and more relevant prior art references shown to you. So this is these are two different operators. One is used to broaden the scope of the search, and one is used to increase the relevancy of your search. And once you run the search string, then all the prior references, maybe 10, 20 or 50, whatever number of comes in the search, you will have to evaluate each one of them. So once you are satisfied that this is my search string and I will study these references to evaluate my patent application, then you have to read each one of the relevant patent application to assess whether my invention is novel, whether it is inventive, and whether it has some industrial application. So industrial application, the third criteria of patentability, is not that much stringent, because every innovation has to have some sort of application in industry. Either it can be made in industry or it can be used in industry. So the third criteria is always, in 99.999% cases, this criteria is not a problem. This is automatically fulfilled. So the two criterias, three rather, the novelty, the inventive step, and the obviousness, these are criteria we need to worry about when we file a patent application. So I will like to talk through some examples about novelty, inventive step, and obviousness. So for example, let's take the bicycle example again. Your innovation is related to bicycle, which has a handle, a seat, a chain, and two pedals and two wheels. So this is your innovation. Assuming that you have invented a cycle which has a seat, a handle, a chain, two wheels, and two pedals to run it, right? This is your innovation, and you are claiming this as your innovation. So what prior art search will do, or the patent office will do, when you file a patent application during the prosecution, they will run search strings. Okay, so during the search string they come across a prior art or prior publication. It can either be a patent or a non-patent literature, and the literature is talking about that the prior art is disclosing or talking about a cycle which has a seat, which has a handle, it has a two wheels, it also has two pedals. So everything that your innovation has, or you want to claim in your patent application, or claimed in your patent application, each and every element of it is disclosed already by some publication. So for example, you filed a patent application on 1st January 2026, and that prior art was published because cycles were already there in public domain for many years. The prior art was from 1990s, and it disclosed that the cycle has a handle, it has a seat, it has a chain also, it has two pedals and two wheels. So based on this single disclosure, I mean, one patent or one prior art is disclosing about each and every element of your innovation. So your innovation failed a novelty test, because if one single prior art reference disclose all elements of your innovation that you are potentially claiming in your patent application, if a single prior art or single prior reference or publication disclose everything of your innovation, then novelty of your innovation is dead. The patent office will say your innovation lack novelty, that's why a patent will not be granted to your patent application. So the first criteria is novelty, and this is how novelty is assessed of a patent application. In the same example, let's assume the patent office couldn't get a prior art that disclose a single prior art that disclose all the elements. Let's assume that the prior art doesn't talk about the two pedals. The prior art does only mentions that there is a bicycle, it has a seat, it has a handle, it has a chain, it has a two wheel also, but somehow it doesn't have two pedals to move the bicycle. So this is the prior art they identify. Because this prior art is not disclosing all elements of your innovation also has two pedals. So because this prior art doesn't talk about two pedals, so it is assessed, the patent office will say that your innovation is novel, it has passed the novelty test. But because there are other criteria also, so they will now move to the second criteria or second assessment, which is the inventive step assessment. So for this, what they will do, because single prior art reference failed to disclose all elements of your innovation, they will try to identify one more prior art that may disclose something about pedals. So one prior art is talking about a bicycle that has a seat, that has a handle, a chain and two wheels, but it doesn't mention anything about pedals. So the patent office will perform more searches to identify if someone talks about a cycle with pedals. So let's assume they identify one more prior art which talks about a cycle with two pedals, right? So now they have identified pedals also. So one prior art is having all the element minus pedals, and the second prior art having a cycle with pedals. So if we combine these two prior art references, this is called prior art mosaicing. All the elements of your proposed innovation are deemed to be disclosed in the prior art. So the patent office will say that each and every element of your innovation, it is true that it is not there in single application, your innovation has novelty, but because all elements of your innovation are already there, maybe in two or more than two prior art references, but they are disclosed in public domain. What you have done, you have simply combined these the teaching of these two prior art references, and you come up with your solution or your innovation. So this is how the inventive step objection is raised. They will identify two or more than two prior references to anticipate all elements of your innovation or your claim, and then combine them together to raise the lack of inventive step objection. So this is second criteria of patentability. One more criteria I mentioned was obviousness. So there is third criteria of obviousness, which is that, let's assume in the same example, the second prior art reference which talks about two pedals. Let's assume that there was no two pedals in that prior art reference, only one pedal was there. So what patent office, because in this case, because only one pedal is there and your innovation or your claim is about two pedals, so the lack of inventive step criteria is also somehow fulfilled. But what patent office does mostly, every jurisdiction, not only in India, US, and every regime, every patent regime, either it can be US, China, or wherever, this obviousness is also being introduced to assess whether something is obvious to a person skilled in the art. So if the patent office identify a prior art that has only one pedal, not the two, then what they will say, that because pedals were known in public domain already, and it is very obvious for a person, if someone if someone is from, excuse me, if someone is working in this domain of bicycle, if he is aware of pedals being used in cycles, then it is obvious that if one pedal can be used, two pedal can also be used. So this is how obviousness criteria is used to assess inventive step. So if the patent office raises these kind of objections in during the prosecution, they will raise lack of novelty objection, lack of inventive step objection, and lack of obviousness objection. So these are three very much used criteria for checking patentability. I'm sorry. I'll continue. Okay, so now we have covered how searches are conducted, how novelty, inventive step, and other criteria of patentability are used or used by the patent office to assess the patentability of your invention. So once you let's assume you are performing your patentability search or patentability assessment yourself, and you come up with a prior art reference, then what you have to do uh, so that you can assess the chances of filing a patent application even though something is already disclosed in public domain. What you have to do now, you have to shortlist the most relevant references from the patent office, from the prior art search that you have conducted, and then you have to assess each one of them in detail so that you can check whether there is some scope is there that you can leverage to file a patent application. So you will shortlist all the closest, maybe 3 or 5 or whatever number of prior art that you deem relevant. You assess them in detail, because a patent document is very lengthy. It is generally 30 to 35 or 40 pages long. So because if you read only the abstract of a patent application, it is not that convincing that you can take opinion or take final decision to file or not to file patent application. You will have to go into the details and then try to see whether what my invention is want to claim is everything disclosed in that prior art reference or not. So you will shortlist all the references and then search in detail about everything that you want to claim. So I will now come to post search procedures and how patent application drafting starts. So you identify the closest prior art references or the most relevant references, and you will study them in detail so that you can make an opinion what level of disclosure is there in those references, whether any technical difference is there in that patent application in those prior references or not. So what is a technical difference? If we take the same example of bicycle, your claim is that my cycle has a seat, a handle, a chain, and 2 wheels and 2 pedals, but the prior art reference is disclosing only about a bicycle with a seat and a handle and a chain, and it doesn't use 2 pedals, for example. So what you will do, you will identify this as a technical difference, that my innovation has 2 pedals extra, which is not been disclosed by any of the prior references. So this is one difference. Likewise, you can identify other differences also, so that you can assess whether on what ground I can prepare a patent application and what I need to highlight in my patent application. Because if let's assume you didn't perform any prior art search, and you will prepare a patent application simply claiming that my patent application is to claim a bicycle that has a seat, a handle, a chain, 2 pedals and 2 wheels. You are not aware about the what is already been there in public domain, because you didn't perform any searches. So your patent application didn't highlight any particular aspect of the invention which has the true novelty or true inventive step, right? But if you conduct a search, you now know that your innovation, up to what level your innovation is already disclosed in public domain. So now you know that a prior art discloses about a bicycle with seat, a handle, and two wheels, but it doesn't talk about two pedals. So now when you start drafting your patent application, you will highlight this aspect of the invention, the presence of two pedals, as the novel feature of your invention and inventive step of innovation. You will talk about the the background. In the background you will talk about prior art, what kind of prior art are available, and how your innovation is different than those prior references. So you will emphasize on only on those aspects, because now you have done the searches, you know that what is important, or what is absolutely different in my innovation. You will do everything to highlight that, or put emphasis on that. So you will put emphasis on the presence of pedals. You will emphasize how it is contributing to the inventive step of your application, how it is changing the landscape of bicycle if you introduce pedals in your bicycle. So this way you will emphasize more and more about the truly novel or innovative features, right? So this is the benefit of identifying prior art searches when you perform prior art references, when you perform these prior art searches. Now you will assess whether everything is already disclosed by the prior in the prior art, or only a part of is disclosed. So if everything is disclosed, then there is a potential hurdle to the novelty of your innovation. But if something is missing in the prior art references, then you have a scope, and only the patent office will challenge your innovation or your application based on inventive step assessment only. Right? So you will assess novelty and inventive step of your innovation. And obviousness, I mentioned about obviousness assessment also. So you will assess whether if I file a patent application, whether these kind of objections will be raised by the patent office or not. So you can assess these potential objections from the prior art search. And once you identify the technical differences, as I mentioned, you will project your application. You can give shape to your patent application accordingly. So if you are aware that something is already disclosed in public domain, now what you have to do, you have to highlight or emphasize only on those aspects which are truly novel or truly inventive in nature. You will not file a patent application with generic language or generic sentences. You will file a patent application, draft a patent application that emphasize on the presence of pedals, importance of its various objectives of having a pedals in your bicycle. So you will emphasize on the objectives, different objectives, and different advantages of having pedals in your bicycle. This way you will draft a patent application. I will talk about claims. So when you draft a patent application, there are different sections. So in a patent application, the most important section of a patent application is the claim of your patent application. Claims define the true protection you will get in your patent application. You will talk n number of things in your patent specification or the body of the application. The only thing that matters or that is going to give advantage once a patent is granted is the claim of your patent application, and particularly the independent claims. So the first claim or the broadest claim of your patent application is called the independent claim, and all other claims are dependent on the independent claim or first claim. So independent claim is the broadest claim of your application. So in the example of bicycle, you will say, I claim a bicycle having or comprising a seat, a handle, a chain, two wheels, and two pedals. This is your claim. So if, let's assume, a patent is granted, then you are getting a protection on this particular claim. Everything, if you mention that my bicycle run at this much speed and it can do this, it can do that, so this is all immaterial. The only thing that matters at the later stage of your patent is the independent claim of your application. So this is your claim. Broadest claim is called the independent claims. Let's assume that if the patent office come across with similar bicycle, then what you are required to do, they will not refuse your patent application. They will ask you to specify what difference is there in your application or in your innovation. So now you will have to amend your independent claim, because this particular independent claim is anticipated by the prior references. Now you will have to amend your independent claim and make it more specific, so that more specific feature of your innovation can be can bring into the independent claims, and a more narrower claim is granted to your application. So the role that patent office plays is to balance the claims. So based on the prior art search, they will ask you to amend your claims, so that the patent is not granted in that form that it will infringes upon the rights of already present prior art products or prior art innovations. So let's assume that this much broad independent claim is granted, then it will infringe on already available prior art products. So for example, if something similar prior art bicycle is available, then this much broader claim will infringe or encroach upon the rights of rights of the people which invented this kind of bicycle, right? So the patent office will say that because this kind of bicycle is already available, you have to amend your claims and introduce some features which are truly specific to your innovation. So this is how independent claims are drafted or balanced. A balance is created in independent claims. Now I will come to filing and other procedural events that follow the patent application drafting. So first is the conceivement of idea of some sort of solution, and then you will conduct prior art search to identify or assess the novelty or inventive step of your innovation. Then the patent application drafting comes. You will draft or write a patent application that disclose or mention different features of your innovation, and you will draft your claims. So this is the part of patent application drafting. Once your patent application is drafted, now comes the patent application filing part. So patent application can be filed in two ways. It is either can be provisional patent application or complete patent application. So if you are ready with your patent application, you have done all the R&D work and you are ready with everything, you are 100% sure that my innovation is ready and I'm not going to add any further things to it or not going to change it any further. Your innovation is ready and you will file a patent application with complete specification. But in case your idea is a very nascent stage and you have just thought about it and you are not fully aware that what you are going to add in this and how the innovation is going to work, then but at the same time you want to protect your innovation from, to give some sort of protection. So this for all those innovations which are not truly complete and more work is required to be done on that so that it takes the final shape, in those cases provisional patent applications can be filed. So provisional patent application gives you first level of protection. So for example, you come across with idea and you are worried that if I disclose or I discuss this thing about with maybe my friend or with my colleague, then there are chances that it can be there can be a theft and the other party can file a patent application for it. So to secure your innovation at that level, you can file a provisional patent application. So this is broadly two types of patent application filed in patent regime. After filing of patent application, publication of your patent application happens. So once you file a patent application, after 18 months from the patent application to filing date, your patent application is published by the patent office on their official journal as well as on their website. So when you file a patent application, an application number is allocated to you. The same application number can be used on the portal to access the application. This publication can happen, if you don't want to pay additional fee for publication, then it will publish after 18 months automatically. But in case you want to tell the word that you have filed a patent application and spread the word, you can, what you can do, you can apply for early publication, and within 1 month your application is published, and you can share it with your friends or your colleagues or anyone. You can disclose it to anyone without worrying about the theft of your idea or your innovation, because you have already secured your patent application by filing a patent application. Now you can disclose it to anybody. You can disclose any kind of stakeholders. Maybe if you want to make a prototype, you can disclose it freely without worrying about theft of your idea, right? So I talked about early publication. If you want to not wait for 18 months for the publication of a patent application, you can file request for early publication. It requires an additional fee, of course, but your patent application will get published within 1 month of time. After publication, the prosecution demands, or the patent office asks you to file a request for examination. So only when somebody files a request for examination, it can either be you or some of your competitors can also file request for examination. So once you file a request for examination, then only the patent office is going to review your patent application and grant a patent once the examination is completed. This process of examination, because on a daily basis thousands of patent applications are filed in India, so every patent application goes into examination queue. So this queue is very lengthy. So there can be 10,000 of patent applications waiting examination. So for some people, there is this provision of expedited examination. So for example, women inventors can apply for expedited examination. Startups can apply for expedited examination. Government bodies and universities can apply for expedited examination. So there are certain category of people who can apply for expedited examination. In this expedited examination, there is a separate queue which is different from the normal queue. So because once somebody files for expedited examination, and not everyone can file, this examination queue has comparatively lesser number of patent applications, because expedited examination also there is an additional fee to be paid. So not everyone choose to go for expedited examination, but it is a surety that if you choose this expedited examination route, your patent application get examined very, very soon. So this is expedited examination. So now comes the prosecution part. Prosecution is nothing but the examination of a patent application. Once you file a patent application, patent office will assess patentability of your innovation, and they will conduct prior art search to assess the novelty, inventive step, and industrial application. On these three parameters, they will assess the patentability of your filed invention, and they will conduct this examination. This is called examination. So once they have conducted the examination, they share a first examination report or FYI with you, with the inventors or the applicants. In this report, they will share their objections or observations in terms of what is already been disclosed in public domain in the form of prior art. So they conduct the examination, they will identify certain references which are closest to your application, and they will prepare a report and share it with you, which is called this first examination report or FYI. So once the examination report comes to the inventors or applicants, they need to prepare a response to it. So for example, a report says that your innovation lacks novelty or it lacks inventive step. Then it is not that your patent application is outrightly rejected by the patent office or refused. They will share their observation and seek your reply on those observations. What is your take on it? So they will give you opportunity to hear your thoughts on their observations. So now you will prepare response. If they mention that your innovation lacks novelty, then you will counter argue that this prior art that they have identified doesn't disclose this thing or that thing, and based on these kind of argument or counter arguments, you will prepare a response and fight with the patent application or argue with them, patent office, to secure a patent for it. This is kind of two-way process. You file a patent application, they share a FYI, and then you file a response for it. Then they will review your response, and they again come up with second examination report or SCR. Then you will again file a response for it. So this kind of thing happens, and there are hearings also. So for if examiner thinks that you are not appreciating what they want to say, they also set up hearings also. So the applicant or their agents attend these hearings to understand what they really want to understand from your invention in this response to examination, and hearings are scheduled by the patent office. So through virtual modes, the way we are doing this, the hearings are conducted at one side. These are patent examiners, and on one side either you or your patent agent is there, and they argue or counter argue with each other to challenge the novelty and inventive step objections raised by the patent office. So this is whole part of patent prosecution. After the patent, if once everything is done during the prosecution, then the final disposal happens, and which is either in the form of patent application grant. Either you will get a patent grant or the patent application is refused. So this is the end of the journey of patent application. Either you will get a patent granted if you successfully able to convey that your innovation has these novelties, these inventive steps, and patent office appreciates those pointers or those emphasized pointers, and they will grant a patent. In case they fail to appreciate it, they will reject it. So this is the end of it. Now finally I will talk about blunders every innovator should avoid. So if something comes to your mind and you want to protect it through patents, the first thing is that you should not disclose it to anybody without filing a patent application. It could either be provisional application, as I mentioned. It is very simple. If you want to file a provisional application, you can simply write down your first level of idea on a paper, and you can take a scan copy of it and file it as a provisional application. This is as simple as that. You just write down your idea and file it as a provisional application. So once you file a provisional application, you will have 12 months of time to file the complete specification. You will have this 12-month period to do proper R&D, to proper prepare your patent application with proper claims and proper specification, and each and every requirement that is going to be there to file a patent application. You file a provisional application, and you have 12 months period of time to complete your innovation, your R&D, and prepare a formal complete specification. But one thing is sure, that if you have some idea that you want to protect, you should not disclose it to anybody. It can be your friend also. You should not disclose it to that person because there is always a chance that maybe you reveal it to your friend and he reveal to someone else, or she reveal it to someone else. Then this way it get propagated from one person to another, and maybe because India follows first to file system. So you reveal it to your friend, and your friend wrote a patent application and file it before you filing a patent application. Then because India follows first to file system, because he filed patent application first, the priority will be his. You cannot claim that I conceived this idea first and this patent should be granted to me. The patent will be granted to only that person who first filed the patent application, right? So you should not disclose this idea to anyone before filing a provisional application. The second thing is that you should not delay filing the patent application in the lure of perfection. You are thinking that I've just thought about an idea, I need to make it perfect, I need to work on it so that it gets the shape that patent office appreciate. As I mentioned, once you file a provisional application, you will have 12 months of time to make it perfect. So do not worry about perfection. You have once you file a patent application, provisional application, you will have 12 months of time period to file a perfect patent application with proper R&D and proper things. So don't wait for idea or innovation to get perfected. As soon as you get idea in your mind, first thing you should do, you should file a provisional application, so that you get the first level of protection from stealing of ideas or idea thefts. Because if you talk about something and it is revealed by someone to someone else, then you lost your chances of getting a patent application filed. The third mistake that most people, not only students but many professional inventors, they do is that they do not perform searches, or if they perform searches, the searches are not that comprehensive. They simply run their search strings on Google. I've seen people who run search string that I have come up with this idea. They quickly go to Google and try to check whether something similar exists or on Google or not, because Google is not a database for everything. It has most of things, but it doesn't have anything, particularly the patents. So you go to Google and run search strings and you don't find anything, you will say, wow, there is nothing like me, and I will file a patent application. And if when tomorrow patent application perform the thorough search on patents, they will see that someone has already filed a patent application, they will reject your patent application, right? So it is very, very important to perform searches. It can be done by your own, but at least you should do some level of searches on patent databases, because not everything is converted into patent, into product, actual products, and not available on Google or other search platforms. So because most of the ideas nowadays are filed in the form of applications, patent application, and the actual product see the day of the light many years later, right? So if you come up with something in your mind and you are thinking about filing a patent application or for your patent application, the first thing is that you should conduct a prior art search, a thorough prior art search, I will say, so that you will not waste your time, money, energy in perfecting the idea, drafting the patent application, filing it, applying for a patent application, waiting for its publication, its prosecution, only to find out that that idea is already disclosed by someone and you will not get a patent. So all those efforts, all those money that you put in goes into vain, right? So it is very, very important to perform prior searches. One more blunder that people do is that drafting a patent application with wrong foundation. So this all happened again because the prior art search was not conducted properly. So if I give this example earlier also, you have your idea of filing a patent application for bicycle, but because you didn't perform a search, you thought that everything that I conceived is novel, and you write a generic patent application without emphasizing any particular point. You write a patent application, you didn't highlight anything out of it. You just mentioned that I have made a bicycle and this is my claim, and please grant me a patent for this invention. Because the prior search was not conducted, the entire application is written in a very generic manner, nothing is emphasized. Let's assume if you performed a prior search, you were aware that prior references disclose a bicycle, but they do not disclose about pedals or maybe a chain or maybe a wheels. They are not disclosing about these things. Then what you can do, you can make a proper foundation for a patent application. You can emphasize on the fact that these things are not there in public domain and these things are truly novel in my patent application. And this way you can write a proper patent application that has proper foundation, and on those foundation you can fight with the examiner and argue with the examiner that these things are not there in public domain. My invention is novel in that way, it has so and so features, so please grant me a patent for these features. So this is again very, very important. The last blunder I would like to talk about is unbalanced independent claims. So as I mentioned, in your patent application, the most important thing is the independent claim. So independent claims are important because let's assume your independent claim is very broad, then the chances will be that prior art searches, broad prior art searches will encroach, you will encroach on the already identified or already present or published patent application. You will encroach upon it. So for example, if your claim is very broad, chances are that many patent application will be relevant for your application because it is very broad. So for example, you only say in your claims that I made a bicycle, you simply say it, then the prior art search will be conducted and the examiner will identify a prior art and he will say that bicycles are already there, your claim is unjustified, you will not get a patent for it. So this is broad claim. Now you have to make it narrow. So like if a claim can be very broad, the same way it can be very narrow. So now you mention that my bicycle has a seat, it has a chain, it has two wheels, it has two pedals. Now you are narrowing down your claim, you are making it more and more specific. So now the burden is on patent office to identify a prior that disclose each and every element of your claim. So now because you made your independent claim very narrow, it is right that no prior art is there that disclose everything about it. This way a patent will be granted to you, fine, you will get a patent for your narrow version of claims. But when you actually going to enforce your patent application, if somebody makes a similar bicycle and your claims are about a bicycle that has seat, chain, wheel, pedals, but the other party or your competitor not include one of the items of these claims. So for example, he make a bicycle without pedals, let's assume he make a bicycle without pedals. So you cannot say that you are infringing my patent. Why? Because in patent jurisprudence, a patent is enforced or other party is deemed to be infringed on your patent only and only when each and every element of your independent claim is established to be there in that particular competitor's product. So for example, if your independent claim has 5 feature A, B, C, D and E, then all those 5 features A, B, C, D, E needs to be there in the competitor's product to establish the infringement. So that is why it is important to balance the claim so that it doesn't encroach upon the already published prior arts, and it is not that narrow that you cannot enforce your patent on your competitors. So a balanced claim drafting is again very important. So these blunders you should note, and you, if assuming that you will be filing patent application someday, you should keep these things in mind. It will help you get a very good claim granted for your patent application. You will be in a position to draft a well balanced patent application, well balanced claim, and you will get patents which is truly enforceable, and you will get a worthy patent which can be enforced and which has some values for your innovation in securing it. Now finally, my closing thoughts: you should train your eyes to identify or appreciate problems in day-to-day life, because it is not I will have to tell that this is a myth that only very complex things are patented. This is not true. Even simple things like safety pin, if you search, you will get to see that there is a patent for safety pin also. So it is not that your innovation needs to be very terrific, out of the world, maybe for rocket, then only you will get a patent. Even for simple to simple things you will get patents. So you should train your eyes to see what problems are already existing with existing products, what is there that you can solve. Think the innovators thinks from this perspective. What they don't think that what I can make, they think from this perspective that what I can solve, what problem I can solve. So you have to develop this mindset that you identify problems in your day-to-day environment, in your school, in your college, in your home, in your, I mean, everywhere, any environment, you see some problem, you should think about it whether I can solve it. If you can solve it, then you can get a patent for it. The only criteria that you need to fulfill is that it should be patentable, it should be patent eligible. I mean, someone has already not filed a patent application, or he should not have disclosed the same thing already. So if you have this mindset of observing problems and coming up with solution for those problems, then you can be inventor someday, and you will get a patent for it someday. So not just create solutions, protected by patent also. So thousands of uh, thoughts crosses our mind on day-to-day basis, but not every thought is converted into patents, right? So if you come up with something which you are passionate about, I mean, if you are you observed some problem and you are passionate to solve it, then try to file a patent application for it, because only if you are so much uh, passionate about filing patent application, then chances are that you will maybe that you will not get a patent for that particular thought, but because you have developed this temperament of filing patent application, solving problems, then on maybe on that particular case you will get a patent, but for other problems that you see, you will get a patent. So when you create some problem, sorry, you solve some problem, you identify a solution for it, you can perform a prior search to assess its patentability, and once you are some level, you have some level of confidence that it will get patent, because not not everything is disclosed in public domain related to that application, you should file a patent application for it. The one more thing is that you should embrace imperfection, because it is not true that in the first go itself you will get a perfect solution, right? So if you observe a problem and you get a solution, then the solution cannot be perfect in the first go, you need to work upon it. So you should appreciate that everything that somebody has made, it was imperfect at one stage, and only when he decided to make it more, work on it and refine it and make it more efficient, then only it evolved to a greater thing or greater innovation. So embrace imperfections, because once you come up with some solution, it is true that it will not be perfect at the first instance, you need to work upon it and you will make it perfect, I'm sure, because if you put in efforts, then anything can be made perfect, and you put in more and more efforts, it will evolve to become something good. Now this platform is open for you. If you have anything to ask related to patents and whatever we have discussed, or anything, you can feel free to ask me.
Thank you, sir, for that truly insightful and engaging session. Your perspectives on intellectual property, innovation, and how ideas can be strategically protected and positioned in the market have given us a lot to think about. I'm sure everyone here is walking away with a clearer understanding of how to turn ideas into real valuable assets. Now, we'd love to hear from the audience. If you have any questions, please feel free to raise your hand or drop them in the chat. Let's open the floor for questions.
Yeah, please.
Darsh Khater.
Hi, good evening, sir.
Good evening, very good evening.
Yeah, sir. For you, so my question is like, for early stage entrepreneurs, how important is filing a patent versus focusing on rapid execution and market entries? Like, if an early stage entrepreneur wants to file a patent, so at what field should he focus more on filing a patent, or on rapid execution and market entries?
Right. So this is very important question, and I'm glad you brought it up. The thing is that, as I mentioned, if you have some solution and you are working on it, marketing for it, then chances are that that idea may be leaked and someone else can also work on it on similar ideas. So it is equally important to file a patent application. You must file a patent application, a provisional application. It doesn't cost you much. Simply write down your idea or your innovation on a plain paper, and only 1600 rupees are required to file a patent application, provisional application. If you do everything by yourself, you perform a prior search yourself, and you draft a provisional application yourself, maybe you can do it with ChatGPT and file a patent application. Only 1600 rupees are required to register your idea and secure it at the very first level. Once you, before disclosing it to somebody and getting a threat of its steal, it theft, it is always better to file a patent application, provisional application.
Thank you, sir. Thank you so much.
That was very insightful. Thank you, sir. Moving on to the next question, Riti Chawla.
Good evening, sir.
Hi, good evening, Riti.
Sir, if a startup has limited funds, should they invest in patenting or scaling their product first?
This is, the same thing I mentioned. It is very, very important to file, because you are working on your startup. The whole concept of a startup is based, the USP of a startup is on a particular inventive feature. If you don't protect it by way of filing a patent application, what if somebody steals the same idea and make us or create a second startup for the same thing? So it is better, always better in fact, to file a patent application for it and secure your core innovative feature. So for if tomorrow someone copies your idea, you can enforce your patent, and you can stop his startup from making the same product. So it is very, very important to file a patent application. It is true that you need funds to scale, but what if after scaling you get to know that somebody else is also working on the same idea, and he's becoming a competitor for your similar concept or similar ideas that you are making in your startup? So it is always better to file a patent application. It is utmost necessary to file a patent application. So if tomorrow comes up with the exact same thing in exact same manner, that at least you can sue him for infringement.
Thank you, sir.
Moving on to the next question, Aditya P, you had a question.
Good evening, sir.
Hi, good evening, Aditya.
So I wanted to ask, how do international patents work, and when should a startup consider filing outside India?
Okay, so there is nothing called international patent. Patents are jurisdictional rights or territorial rights. You will have a patent for India, you will have a patent for US. You have to go in each and every jurisdiction, each and every territory. You will have to file a patent application there, and then only you will get patent rights in that particular territory where you filed and prosecuted your patent application. One thing is there, one international patent application you can file, which is called PCT application, or Patent Cooperation Treaty application, where you file a single application and the same application can be taken into multiple jurisdictions. But there is nothing called international patent. International patent is like you get a one patent, and the same patent can be enforced in all the jurisdictions across the world. This is not true. You will have to file multiple patent application in multiple jurisdictions, so that if only you will get patent in those jurisdictions, you will then enforce your patent application, your patent. But it is not that you file a patent application in India and you can enforce your patent in US. Your Indian patent is valid only in India. You cannot enforce it in US, or the US patent cannot be enforced in India. So I missed your second question. What was that?
When should a startup consider filing outside India?
You will have to, every startup needs to assess their potential markets, right? So when they see that the potential is there in other jurisdictions also, not only in India, they see the potential markets in other jurisdictions, then you will file a patent application. But you need to remember one thing, that a patent application can only be filed in other jurisdiction only within 12 months of time period, if conventional patent application filing route is performed. So there are two ways or two routes to file patent application abroad. One is called conventional route, in which you will go each country, file a patent application there, prosecute it and get a patent. This is called conventional route. One more thing I talk about is PCT. You file a single application and the same application can be taken into multiple jurisdictions and get a patent there, right? So you have to if you have filed a patent application, you have to decide in those 12 months period that whether you want to get a patent in other jurisdictions also or not, because once this time period has elapsed or gone, you are not allowed to file the same patent application in other jurisdiction. So you have to assess these things at the time of filing the patent application or within 12 months of period.
Okay, thank you, sir.
That provides great clarity on the topic, sir. Next question is by Naomi Janger.
So, what's one advice you wish every student knew about patents before starting out?
The thing is that every patent is very valuable. If you want to protect your ideas, you want to secure and you want to make a tangible asset, because all the ideas or thought that cross our mind, those are intangible, they cannot be touched upon, right? They are intangible. So if you want to create some value, you need to convert it into tangible form, and patents give you platform to convert your ideas, intangible ideas, into tangible forms, right? So if you have a patent, that is that you have the patent office has validated your idea and given you patent and granted you patent because that idea was assessed on 3 parameters of patentability. So every student who thinks that he has solved a particular problem in a particular manner and that problem is very important for the mankind or maybe for industry, then they should file patent application, because the fee is very nominal. Only 1600s are required to file a patent application. So this fees is nothing in terms of other expenditures we made in day-to-day life, right? So every student, if they are very particular about securing ideas, then they should definitely file a patent application.
That was a great point, sir. Moving on to the next question by Jas Solanki.
Good evening, sir.
Hi, good evening, Jess.
So, do you think patents actually create real competitive advantage, or is execution still biggest differentiator?
Yeah, of course. As I mentioned that, let's assume you are a startup or you are a company, you are putting efforts to create something, and if you don't protect your IP or intellectual property, and if tomorrow somebody stand up and make a similar product which is similar to your, then and maybe because they didn't put in efforts during making of the product, that you spended hours of time, money and efforts in making it, and he simply copies it. So it is quite a possibility that their product can be a cheaper version of your product, right? Because you have put in a lot of efforts, you have R&D teams to come up with that particular product, and your competitors who simply see your product and create a copy of it, but because you don't have a patent, you don't have IP secured for that patent, he can make a similar product and in a much more reasonable prices he can sell. So you have lost your USP. All the efforts that you put in to make that particular product, evolving it, has gone into vain, because that particular competitor is selling the same product at a very cheaper prices. So market value or market share will go to that person, obviously, right? So in that terms or in that perspective, it is very important that you secure your ideas in the form of patents. So not just patents, even the design or look of your patent, your product can be patented through design patents. Your business name can be protected through trademarks, and there are other forms of IP also. So you should think of something about securing all the IPs. Maybe the kind of brochure you are making for marketing of your product, you should copyright it. So there are different forms of IP that you need to secure to make a shield around your product, or to make it secure from every angle possible. This is very important.
Thank you, sir.
Yeah.
Thank you, sir. That was very helpful. Moving on to the next question by Shri Hasini.
Good evening, sir.
Hi, good evening, Sirasni.
I wanted to ask, how should founders handle the risk of idea theft before they pitch to their investors and before they file a patent?
Could you please repeat again?
But how should founders handle the risk of idea theft when pitching to investors before they file a patent?
Could you please rephrase it, because I'm not able to understand the question?
So one second. So I wanted to ask, how should founders handle the risk of idea theft when pitching to investors before they file a patent?
Okay. So this is very simple. I mean, you have to simply file a provisional application, and that will secure your innovation, because once you file a patent application, provisional application, patent application number is allocated to you. So once you are pitching your idea to investors, you can cite that application number on your pitch and say that you have already secured your patent application, your innovation, through this patent application filing. So that way, not only you secure your idea, you will impress your investors also that you are aware about IP, protection of IP, and your innovation or your product is more, it has more leverage to it because you have secured, and others compete. It is not easier for your competitors to make a similar product.
Yes, sir. Thank you.
The next question is by Aditya.
Hello, good evening, sir.
Yeah, hi Aditya.
So I want to ask, sir, in which type of startup patents are more important, like in deep tech or the service-based startups?
This is nothing to worry about what sort of startups should file a patent application. If you feel that this is if your IP can be copied anywhere, it can either be, because I mean service based, these are only the IP is in the process. So in those startup also, and those which are working in deep tech, I mean it is equally important for each one of the startup, whether working in deep tech or in service based startups. It is equally important for everyone to secure their IP, because anyone can steal any kind of IP. So it is better that you at least, maybe let's not think about patent grant, let's think about filing a patent application, right? So you filed a patent application, so maybe 1 or 2 years of time you will have that leverage, because the final disposal of your patent application has not been done. There is always, you will scare, you can create a scare that I filed a patent application, it will get a patent granted anytime. So once you spread this word, the potential competitor of yours, they will have this thing in their mind that if I copy and if a patent is granted tomorrow, then he can sue me for infringement. So it becomes a kind of hurdle for them to copy your product. So it doesn't matter whether you are working in deep tech or high tech or service based startups. You should, if you feel that it can be copied, then definitely you should file a patent application for it.
Okay, sir. Thank you.
Thank you, sir. That was a valuable point. Moving on to the next question by Astha Singh.
Good evening, sir.
Yeah,
My question is, what are some common mistakes students or first-time founders make while filing patents?
Though the first prominent mistake that is done by students mostly is that, because I've seen a lot of universities, not only independent students, they're filing patent application for, I mean, absolute trash. They don't think about what needs to go into the patent application. They will say n number of things in their patent application, but they forget to focus about the important inventive feature of their patent application. I've seen thousands of patent applications filed by prominent universities, but their claims are written either in one word, either in one sentence, and that particular sentence doesn't mean anything. So what happens, the patent office outrightly reject their patent application because the claims are not properly formulated, the application is not in preferred format the patent office appreciate. So the first thing is that you should first at least see few patent applications of your domain, the domain you are working in, or you want to file a patent application. You should you should perform a prior art search on free patent databases, try to review some patent application or study some patent applications, so that you get to know about how a patent application is actually drafted. So once you get a fair amount of idea, then if you don't want to invest in professional patent application drafting, you can at least write a meaningful patent application. So this is the one thing that I also already talked about it, that once someone gets an idea in their head, they rush to file a patent application without worrying about the structure of the patent application, without worrying about the claims. They simply write down a very generic patent application without emphasizing the truly inventive and novel features, and write down a patent application, and what happens? The patent application doesn't see the light and doesn't see the patent grant. This is the biggest mistake.
Thank you, sir. Okay, sir, the next question is by Dhruv.
Good evening, sir.
Yeah, hi Dhruv.
Sir, my question is that what is the typical timeline and cost of filing or securing a patent in India, and how can students realistically plan for it?
So filing if you file a provisional application, you will have 12 months of time period to file complete application. But if we overall talk about the journey of filing patent application and final disposal, if we go by simpler routes or normal routes, the application will take anywhere around 2 to 3 years of time. But if we take the expedited route, which is available to startups, women inventors, women applicants, or universities or government organizations, then we have seen that patent applications will get granted, the patent which is granted in the shortest amount of time is in 4 months of time period. So now if you file patent application taking the expedited route, then patent application can granted, let's assume at a very broad level, in 1 years of time you will get a patent disposal, you will get a patent grant or rejected in that period of amount of time.
Okay, thanks, sir.
Okay, sir, I think that was the last question. Are there any more questions? All right. That brings us to the end of today's session. A sincere thank you to Advocate Lalit Kumar for sharing his time, expertise, and valuable insights with us. Your guidance has truly helped us understand the importance of protecting innovation and thinking beyond just ideas. And thank you to everyone who joined us today for your enthusiasm and participation. Remember, an idea is just the beginning. What truly matters is how you protect it, build it, and take it forward. Have a great day and keep innovating.
Thank you so much, everyone, for being a such kind audience. Thank you.
Thank you, sir.
Thank you. Bye bye. Bye bye.
Thank you,
sir.
Thank you.
Thank you, sir.
Pleasure.
Thank you.